Congratulations to Michigan. Michigan is the very first state in the Midwest to say yes, indeed, to adult use cannabis. In fact, just several months ago in 2018, 57% of people in Michigan voted to approve adult use cannabis. So it is on the move, which is so fantastic and exciting. So if you're wondering what happens now, what happens next, that's what this webinar is all about. And we're excited to share those details with you. My name's Maureen McNamara. I'm the founder and chief facilitator with Cannabis Trainers. And our mission is to help move the industry forward with compliance, integrity, and professionalism. We've created a specialized class for compliance in the dispensary world. It's called Sell Smart. We're super excited. We just filmed it, so it's going to be computer-based learning, launching in about 6 weeks. So stay tuned for that. I've also been involved with the National Cannabis Industry Association, NCIA, now for 5 years, and have been part of their committees for the last couple of years. And so today's workshop webinar is presented to you by this State Regulation Committee, which is a committee within NCIA. And we're a group of professionals from all over the country that gather to make sure we can move the industry forward. As you can see, NCIA has a mission of advocacy, education, and community. And so our work in the committee is to make sure that the regulations in the United States make sense. We desire to inform certainly business owners, but also regulators when we can, and it seems relevant. So that's what I'm up to in the world, and I'm so excited that my colleagues on the committee are with me as well. Barton Morris and Michael Cooper. Michael, tell the team what you're up to in the world.
Sure. Thanks, Maureen. I'm the co-founder and managing member of MadisonJay Solutions, as well as the vice chair of the State Regulations Committee for the NCIA and a member of the NCIA's Policy Council. My background, I'm a lawyer by training, and after graduating from Harvard Law, I spent a number of years litigating regulatory matters and helping leading companies strengthen and improve their compliance systems. After that, I was the general counsel of MHW, which is a leading provider of services in the alcohol industry. And we started this company to help entrepreneurs do what MHW does in alcohol, which is let them focus on their business, help them understand the rules of the road, and implement the practices and procedures they need to build a durable long-term player in the space.
Awesome. Thanks, Michael. Barton.
Good afternoon, everyone. I'm so excited that so many people are interested in what's going on in Michigan. My name is Barton Morris. I'm the principal attorney at the Cannabis Legal Group. We're a law firm comprised of 4 attorneys, and we exclusively assist clients in obtaining cannabis or marijuana-related licenses and perform all of the work necessary to assist with their corporate objectives and structure and help consult those that are seeking to be in the industry. We're off counsel to the cannabis law firm Vicente Cederberg out of Colorado, and we are generally known as the top or one of the top cannabis law firms in the state of Michigan. So I am super excited to assist in bringing some of that information to our attendees.
Great, thanks. And for everyone just joining in, go ahead and find your chat feature. That's going to be the best way to communicate with us. Although we can't hear you, we definitely want to hear from you. And the best way to do that is to find that chat feature. If you're with us on Zoom, you're going to be able to scroll, open that up, and send my panelists, myself, notes. You can also choose to send those to everybody. If you haven't done so already, feel free to let us know from where in the world you're dialing in. As I said, my name is Maureen McNamara. I'm the founder and chief facilitator with Cannabis Trainers, and training has been my gig for decades, since last century. So training is my focus, which is perfect for this webinar. Although Barton and Michael are both attorneys, please know that today is not about delivering any attorney advice. This is not legal advice. It's informational and educational, and we look forward to sharing that with you. Let's jump into some of the details here. So now that Michigan has passed, Barton, give us a little history or overview of the initiative and what has changed since last year.
Sure. Well, let me begin by saying that Michigan was about the 21st or second state that adopted a medical marijuana initiative back in 2008. But we're also the last state that adopted an initiative that didn't contain within it a system for commercial cultivation and sale of marijuana. And so for a long time, we existed as an industry with just patients and caregivers. And we do have a lot of patients. This past year exceeded over 300,000 patients, which is second only to the state of California. So we do have a lot of interest in the industry here, but we didn't have any regulated manner of selling it or cultivating it. So that until now. But during that period of time, I myself and a lot of others were doing everything we could to get this on the ballot, adult use on the ballot. And we did have a petition initiative to get it on the 2016 presidential ballot. And despite getting all of the signatures necessary, the legislature actually stepped in at literally the last minute and took a legislative action to remove our petition or to keep us from getting on the ballot, which was a big setback. But ultimately, obviously, that really galvanized our forces. We combined some organizations and created a coalition, which then began to raise money and a lot more money in order to be able to get the signatures and be able to overcome the legislature's actions and get what we call Proposal 1, or the Coalition to Regulate Marijuana Like Alcohol, onto the November 2018 ballot. And that was, of course, November 6, 2018. It passed with 57% of the vote, as Maureen said, and became effective, as you see in the slide there, December 6, 2018. And so what that means is on December 6th of 2018, now in Michigan, adults have the ability to purchase and possess use 2.5 ounces of marijuana, of cannabis. And then in addition to that, in your homes, like in a residential home, people can be, or it's not people, but adults, of course, can be in possession of up to 10 ounces at their home. So 2.5 ounces, out anywhere, 10 ounces at your home. There's also a provision in there that says if you're going to have 10 ounces at your home, anything over 2.5 has to be locked away in a secure lockbox or somewhere where it's not just available, it's not sitting out. So 2.5 pretty much anywhere in your home, but anything over that sitting in a lockbox. Then in addition to that, we have a homegrown grow provision which allows 12 plants per household, not 12 plants per adult if they're in the same household, 12 plants per household. And in addition to that, anything that's harvested from those 12 plants can be, the adult can be in possession of that as well, even if that exceeds that 10 ounces. And so really there's not a limit other than what can be harvested within those 12 plants. But it still goes to show, it goes for without saying that anything over 2.5 ounces in somebody's residence has to be locked up. And so,
Barton, I want to check in. I know that although the voters passed adult use, there's certainly medical cannabis available in Michigan. Adult use cannabis was approved, but it's not in play yet. Is that right? So that people can't actually an adult that's not a patient cannot purchase 12 and a half ounces, but they could be in possession of 2.5 ounces, not 12.
Right, that's correct,
Okay.
because we haven't begun our commercial distribution for adult use, although we have for medical. And right now we get a lot of questions as well, how are adults supposed to get it? And the fact is that it can be gifted, meaning that one person can gift it to another. A caregiver who is in possession of marijuana as a patient or as a caregiver for a patient can give cannabis to any adult as long as it's no more than 2.5 ounces. It's completely lawful. So that's one way of doing it.
Okay. Got it. And to clarify, if somebody is just an extraordinary home grower and they are growing 12 12 plants, and that produces more than 10 ounces, that is acceptable to have stored at home. Of course, everything over 2.5 ounces is in a secured container. Is that accurate?
That is accurate.
Okay, so if people can grow a lot that of 12 plants, that is accurate. Well, let's share some other details. Now, for those of you that we definitely want to hear from you, we're going to save time at the end to handle all of your questions and answers, or as many as we can in the time remaining. This is being recorded, so you can share it with friends and family in the future. And we'll let you know when it's time to type in your questions. Feel free to pop them in along the way if you desire, and that will be handled in the chat feature. So what else do we need to know, Barton, about what happens next?
So thankfully, our Michigan Regulation and Taxation of Marijuana Act does set up a commercialized system for the cultivation, processing, and distribution of marijuana. And it's going to be similar or even identical to our medical commercialized system, which we did enact finally in 2016 and began accepting applications in 2017. Now in 2018, we began to license actually companies for those applications, and we'll get into that in a second. So the question then becomes, as far as our adult use initiative or law, when does our regulatory body, which is the Department of Licensing and Regulatory Affairs, otherwise known as LARA, when do they begin taking applications?
Let's actually throw that out as a quiz question for everybody. Find your chat feature. And some of you that are dialing from Michigan, you probably know this, but the commitment is that the application window will open in 2019 on the 6th of what month? Ooh, it's like Jeopardy. All right, we've got November. We've got somebody hopeful for next month in February. We're hoping, well, January 6th have already passed. Oops, Sandra thinks it might be April. The commitment by the Michigan regulators, Jenny is correct. We've got Chantal who hoping it's 420. Kim, you are correct. So the window will open no later than the 6th of December. Now, Barton, what's your hunch? Is it going to be December or earlier?
So yes, it is December 6th. The reason it's December 6th is because the language specifies that it has to be, those applications have to be available no later than 12 months after the effective date of the act. The effective date was December 6, 2018, as we saw on the last slide. And so therefore those applications have to be available and begin to be accepted no later than December 6th of 2019. And to answer your question, Maureen, that is the drop dead date as to when that's the latest it's going to be. It's very possible, and some say even likely, that the applications will be made available earlier than that. And for this reason, the application process will be very similar, if not identical, to the medical marijuana commercial application process. So that process has already been laid out. Even our regulations now, they're no longer emergency regulations. They are now final regulations, which are going to be very similar, if not identical, to our adult use program. So, and from my understanding, based upon people that I've talked to, they began working on the adult use regulations almost immediately after we voted, or after the act became effective. And so I know that they're working on it right now. And I know that the medical marijuana program, they got that up and running for those applications in a year's period of time. And that was without any prior experience. And so now they have plenty of experience. And in fact, they continue to make the process better.
Great. Now, as we look at this content, before we move on to even more details, we're getting questions, and we know that if applicants, for 2 years, applicants that have had and I just want to open this up again, it's like Jeopardy chat feature in, priority would be given to what type of applicants? That's bullet point number 4. What applicants that have had what experience for 2 years would allow greater ease to jump into the adult use market? Da, 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 da. Jennifer is correct. That's right. Jeff, yep, absolutely. So for those of you that have or involved in a medical license in Michigan, especially with 2 years of such involvement, you will have a leg up. Tell us just quickly, Barton, anything else about that?
Right, as Catherine has said, and a couple other people have thought that our medical marijuana license holders will be given a priority. In fact, they will be the only individuals that are able to submit those applications, as that's a prerequisite. You have to have one of the medical marijuana license types in order to be able to qualify for a majority of the license types for adult use. I say majority because it doesn't necessitate all of them. As you see in our slide, there's a micro business license. That micro business license is defined as an operator that the license type can cultivate up to 150 plants, process and distribute or do a provisioning center, all under one licensee in that closed loop. So for micro business licenses, you do not have to have a prior medical marijuana license. That would make a lot of sense. It's designed to promote small businesses, and if you add a medical license, that pretty much means you're not a small business. So that is an exception. But other than that, for all of the other license types, which we're about to go into, you would have to have a medical license first.
Great. And then what does this mean with these adult use laws with the Marijuana Licensing Board?
The Marijuana Licensing Board, right now it's called the Medical Marijuana Licensing Board. And that licensing board was set out through our medical marijuana law, which created the commercial cultivation, processing, and sale of medical marijuana. It's called the Medical Marijuana Facilities Licensing Act, MMFLA. That created a licensing board. The licensing board is made up of 5 members of whom were picked pretty much in a political fashion. Like the governor at the time, who was Republican, selected one person, the Speaker of the House or the Senate, the Senate leader, majority leader, and the House majority leader. Each of these political individuals or offices appointed somebody to the board, and so it kind of operates in this political fashion as well. In fact, many people believe that there's a couple of people on the board that literally don't like the industry and trying to be very conservative with the issuances of those licenses. And so it's to many people's delight that our adult use regulation and taxation of marijuana licensing program will no longer have a medical or that licensing board. It'll be only our regulatory department, LARA, will decide whether somebody qualifies for a license.
Great. Thanks, Barton. And everybody, we will have certainly time for questions, so you can keep typing them in, but we'll get to them shortly. So Proposition 1 is the proposition that passed last year by 57% of the vote. So Michael, does this mean all is said and done? What does this mean for us moving forward?
Well, for one thing, I'm guessing most folks on this know, and I certainly know that you know, the answer to that is no. This is something that has played out in a number of states before, and it'll play out in the same way here. To flag some of the things that are certainly unresolved here, one of them is what types of licenses will exist. As Barton was just saying, the initiative references certain types of licenses, some of which exist on the medical side. It talks about retail licensees, safety compliance facilities, which are testing facilities, secure transporters, processors, micro businesses, which Barton was just talking about, and growers. But the initiative, Prop 1, specifically grants authority to the Department of Licensing and Regulatory Affairs to expand license types. So it says in Section 8.2a that they can promulgate rules to provide for the issuance of additional classes of licenses to operate these types of businesses. So you could see an expanded set of businesses beyond just what's available today. Obviously, that has a major impact on what you might plan to apply for, how you might think about your business plan. Another thing that you will see is you're going to see health regulations. There is not an adult use market in the country that doesn't have standards put in place to govern cultivation, processing, distribution. So for example, if you're sitting on this webinar and you're thinking, okay, we're going to produce edibles, you can expect that there will be the type of regulations that apply to your company that you'd see in the food world. Things like sinks, protocols for hygiene, placement of items. Those are all going to be in the regulations, I would be fairly confident. Growers or cultivators can expect regulations to cover acceptable pesticides, things like that. Obviously, transporters can expect regulations to cover how they transport. That is to say, does this have to be a lockbox inside of the car? How much can you transport in a single run? How long of a route can you have for a single run? And I'll just flag, I don't think that this is as likely in Michigan, which obviously has a great history in the automotive industry, but there are jurisdictions where some environmental folks have pushed to say, well, cars shouldn't be actually mandatory, and you should be able to do this through alternate means of transportation. I don't know if that's going to happen in the Motor City, but I think it's worth flagging. You're also undoubtedly going to see restrictions on how you can advertise and market adult use cannabis. The Prop 1 language talks about promulgating reasonable restrictions on advertising, marketing, and display of marijuana. You can expect that there will be rules on time and place of advertising and marketing. You're not likely to be able to see an ad for cannabis on the side of a church or on TV during a kid's cartoon. You're also going to see restrictions on the content of advertising and marketing. So you're going to see a prohibition on not appealing to minors. That appears in every jurisdiction. You're going to see that. The question is, what will that mean and how much color will the regulators provide? Most likely in practice, it'll mean a prohibition on content that targets minors. But if you've thought about this, you know that's an elastic concept on the margins. It can mean different things to different people. And there's a question of what's going to be swept in with that prohibition. Things like some jurisdictions think fruit is inherently appealing to minors, so you can't use imagery of fruit. Some jurisdictions don't say that. The other thing on this slide that's worth flagging is you're going to see a level of regulation at the municipality level. And I think Barton's going to talk a little more about that later. But Prop 1 says a municipality may completely prohibit or limit the number of marijuana establishments within its boundaries. So you can have a ban on marijuana establishments in your jurisdiction. Now that can be challenged under certain circumstances by a voter petition, but even if you don't have a ban, you can still see things like restrictions on signage, hours, things like that. That is very common local time and place regulation in this industry. And municipalities can also adopt licensing rules of their own, although there's a relatively favorable cap on how much they can charge for that.
Thanks, Michael. And you mentioned licensing a couple times. So Barton, give us the overview. I know you've been involved with this. You've got some details about license types, how they're named. Give us the inside scoop.
Our Facilities Licensing Act, otherwise known as the MMFLA, enacted in 2016, authorized 5 license types, as you see there. These same 5 license types were identically brought into our adult use law so that there would be a seamless exchange and application process. Provisioning centers, as many people like to tell me, is a very unique name to call dispensaries or retail establishments. We call them provisioning centers. Our regulators and the drafters believe that using the word dispensaries was potentially going to be confusing, and also it made people believe that they'd be potentially dispensing other controlled substances, which in our law, it is precluded. Now, nobody can use the word dispensary because it does connotate that they're dispensing like prescription medications, and so we use provisioning centers. Growers, obviously cultivation, processors, otherwise known as manufacturing, I believe is the terminology for Colorado. But of course, we're talking about the extraction of cannabinoids from flower and plant products. Secured transporters are companies that have to be used, and that's why we have mandatory there. They have to be used for the transportation of cannabis from one facility to another, unless the facilities are located in the same location, like a grower and a retail establishment that are located in the same place or processor, which is permitted. So that's something that's new, I think, that not a lot of people are used to. And one other thing that's important to know is that a secured transporter, anybody having an interest in that type of company cannot have an interest in any other type of license type. So somebody that owns a provisioning center cannot also own a secured transporter, and vice versa. Secured transporter cannot have any interest in a processor or grower. They have to be separate. But to be clear, we do allow vertical integration within the 3 license types: provisioning center, growers, and processors. So one person could own all 3. That is permitted, but cannot have an interest in that secure transporter or the safety compliance facility testers. When we created the terminology safety compliance facilities, it was done to connote the fact that that's the whole point, is to make the cannabis safe, to make sure that the cultivators are in compliance with those rules. So I've always liked that, because that's one of the hallmarks, I think, of commercialized, regulated cannabis sales, which is we make that product safe, or do our best to make it safe for the consumers, as opposed to black market. So those are the 5 license types, not including the micro business.
And Barton, just to be clear, vertical integration is go. Labs is a common name. Street word lab, but in Michigan it'll be called safety compliance facility. And whoever owns a safety compliance facility cannot also be a secured transporter. License type 4 and 5 on the slide are distinct and separate and in no way involved in any other part of the cannabis world. Is that accurate?
That is correct.
Okay, great. All right, let's see what's next. So when we think about those licensing, you've just updated this for us about an hour ago about how many licenses are going. Anything to add to this? What can we expect to change, or?
So the Medical Marijuana Licensing Board, which we previously talked about, meets every month, and they have a slate. Every month they have a slate of applications that they decide as to whether they can approve or deny those applications. And thus far, after they probably began issuing issuing licenses, I think in April or May of this year. And then every month thereafter, there's been more and more and more. So far, only 54 provisioning centers. I say only because that is throughout the entire state of Michigan, which is a lot of land, and it's a large state. So 54 is not a lot. There could be, I think there's only one, like in the Upper Peninsula. There's a lot of industry worry about the fact that that there's not enough that has been licensed so far. But every month there's a few more. This past month, as you said, we added two more provisioning centers were licensed, potentially two or three, and then 29 growers. Many of those growers haven't even begun cultivating yet because of all of the issues that cultivation presents itself. And so there's only a few that have actually produced product thus far. And thankfully, our newly elected governor and attorney general have been involved and allowed for the extension of what we call temporary operation to permit caregivers to supply cannabis to those provisioning centers. And even allow some provisioning centers that have their license applications pending for them to continue to remain open. And so there are considerably more than 54 provisioning centers that are open right now that are distributing marijuana to patients, but there's only 54 that have been licensed thus far. 10 processors and 4 each of the transporters and safety compliance facilities. And just to note, as of right now, those temporary operations that are allowing unlicensed provisioning centers to remain open and to obtain cannabis from outside of that closed loop system, that is supposed to end on March 31st.
Change is coming. Great. Now, there's a few other things that we want to be aware of about getting a license. Tell us about those.
Well, one of the most important things about getting a state license is that it requires a municipal license. So every municipality gets to decide how many, if any, facilities that they would permit within their communities. So if somebody wants to get a license for any of the 5 or 6 license types, you have to get a municipal license first. And that city has to enact an ordinance to permit and license those facilities. And so that's what has to happen right now, and that is what's been happening with our medical program. We have 1,700 communities or municipalities in this state, and later on we'll talk about how many have actually permitted facilities within their communities. And I think it's also important to note that kind of puts the limit on the number of facilities that we'll have in the state of Michigan. The state of Michigan itself will not limit the number of licenses it will issue. It'll issue the number of licenses as those qualified applications are submitted. But the number of licenses will be limited to the number of municipalities or the number of licenses that the municipalities themselves will permit. Almost every municipality, except for the largest cities like Detroit, or Grand Rapids, they have a small number of dispensaries or provisioning centers that they will permit. You know, some will permit 1, some 5, some 10, and so that will serve as a limit, and then that'll serve to that'll be a barrier to entry. But that being said, there's a lot of cities out there still in the process of making that decision. We permit vertical integration, as I had previously said, and that vertical integration is restricted to provisioning centers, processors, and growers. It does not include, and it will not include, safety compliance facilities or secured transporters. And also of note, it permits stacking of cultivation licenses. We have 3 classes of cultivation licenses right now at 500 plants, 1,000 plants, or 1,500 plants. So the department has issued a regulation that allows for a cultivator to get as many 1,500 plant licenses as it qualifies for, as it applies for. So each application, it has to be evaluated on its merits, and of course each license has to satisfy minimum capitalization requirements. The minimum capitalization requirement for a Class C 1,500 plant grow is $500,000. And so if somebody wanted 10 of those, as long as they can show a minimum capitalization of $500,000 for each and all of the other requirements, then they can get 10, including having the municipality agree to that as well, which would give them the opportunity to grow 15,000 plants. Another thing to note is just that with that minimum capitalization requirement, only 25% of that has to be liquid. So not the entire amount. The rest of it can be satisfied with real estate or with other non-liquid capital things, but 25% of it has to be liquid.
Well, let's quiz everybody. Join me over on your chat feature. Now, Barton has mentioned that some municipalities have opted in, some have not, and so you've got a few choices here, and we're going to invite your guesses. Currently, how many Michigan municipalities have opted in? All right, Jeff is getting 89. The team at Green Koi is guessing 89. Chantel thinks it's 309. Keep those guesses coming in. Let's make sure we get a few. Kim, gotcha. Well, we're going to let you keep guessing just for another moment. But Barton, how many municipalities are there in Michigan? Before you reveal the big reveal, how many of them have opted in? How many are there?
Michigan has 17 municipalities, 1,700 municipalities within the state.
Okay, so how many have opted in?
Answer is C, 309.
I did think it was 109, but is it 309? I like that better.
Yes. You're right.
109.
It is 109. Right. Yes.
So less than 10% have opted in. And just to double check, does that mean those municipalities have said nothing happens in our backyard, or just no provisioning centers? Can they partially opt in? That's
a good question. So when a municipality chooses not to do anything, that means that they would not permit, they cannot have any facilities within their community. So by doing nothing, essentially it means that they have opted out. There have been some municipalities that have actually passed resolutions to opt out by basically trying to send a message that they're never going to opt in. Of course, they can always withdraw that or retract it. But most of those 1,700 have simply not done anything. A lot of, and I've talked to many of them, especially the ones that our clients and the industry is most interested in. And many of them are like, you know what, we don't see any problem with just waiting and see how the industry works out, seeing what type of tax revenue is shared, seeing what the demand is for our municipality and the residents, and see how they react to it. A lot of them have now discussed it. They've been discussing it basically since the enactment of the Medical Marijuana Facilities Licensing Act. These cities and the government officials or municipal officials, they've talked about it amongst themselves, considered it. Many have strong opinions for and against. City attorneys have been involved in providing them with legal counsel as to how to proceed. And all I can say is that I think a majority of those 1,700, the ones that haven't done anything, they're still thinking about it. They're still open to it. And many of them are really like still, they're just working on it right now. Like almost every day, or certainly every week, we hear of another city that has agreed to have a certain number. And we've also heard some cities that have agreed to increase the number now that they've had some within their city. They don't find it so bad, and so they're allowing a few more.
So what I'm hearing is that over 90% have not opted out. They just simply haven't opted in yet, and that could change. Well,
correct. Great.
Well, Michael, tell us about some of the other key questions that we think we're going to be seeing develop in regulations over the year.
Sure. So one of the things that we do is our firm works nationally across the country in the adult use markets. And so there are certainly a number of things that you see just over and over again in this stage of the process that you're likely to see here is significant fights. One of them is labeling. What goes on the label? How is that information presented? Do you need to get pre-approval for your label, or can you put the label on the product without getting pre-approval from the regulator? Things like how many warnings go on the label. And obviously there's an inherent tension between, on the one hand, wanting to provide full and complete information, and on the other, creating sort of an alphabet soup that just turns off consumers and they go, well, dear God, I don't want to buy this product. The other piece of it on labeling is what can go on the exterior. And I think somebody had asked a related question to this through the chat feature, which I know all three of us are looking at if you're submitting those questions and wondering. So part of this is a marketing question, but what can you put on your packaging that goes beyond what's specifically required to be on the label? Things like logos, things like that. What can that look like? And where can it go? There's also the temptation to sort of sterilize this packaging and to make it more and more clinical. Obviously, the the challenge and the pushback that you'll see during this process is people will say, the more you do that, it provides an advantage to the residual illicit market. The scarier it sounds, the less likely somebody is going to pay a premium for a product that's been tested, tax collected on it, et cetera, et cetera. The next thing that you will undoubtedly see a lot of discussion about is child-proof packaging. There are some rules you can expect, and you will see child-proof packaging. There will very likely be a rule that says this can't look like a different product. So you can't make your package of something look like Oreos, right? You also definitely can't make it look like a product that's marketed towards minors. A kid's cereal, you really can't use their branding because somebody might pick it up and think that's what it is. There's also a question of how child-proof packaging requirements will be implemented, whether it'll be permissible to have non-child-proof packaging that gets put in child-proof exit packaging, whether the rules will be the same for all types of goods or just certain types of goods. Sometimes you see a heightened concern around, for example, edibles, because those seem like they're the easiest things for a kid to see and be interested in trying. There's also a question of whether it has to be resealable. Different jurisdictions have taken different approaches. For the folks in California for this webinar, you certainly have seen that in recent days in the new regulations there. The next thing that you are likely to see a significant dispute about are potency rules. Regulations will need to be created for the maximum amount of THC that can be included in products and in servings. This tends to be a contentious part of the public comment period and the general public debate. Sometimes regulators come out with less strong products than were available before on the rationale that those were medical products, and these are not. Obviously, that is big news for someone whose business model is to make something at a strength that is no longer deemed acceptable for the adult use market, particularly because when you're going through this process, I know Michigan went through the process of putting in place a more robust regulatory system recently for the medical market, which Barton has been talking about. But you often see sort of a fresh set of eyes come into the overall program when adult use gets legalized, and it can lead to changes. The last thing that's worth mentioning are product types on prohibited products. So there can be questions about, does this need to be shelf stable? Can it be a dried meat product? You think, well, why would a dried meat product matter? I don't know, maybe this person is on this webinar, but I have a very strong recollection of seeing someone who was incredibly frustrated at a public comment hearing in California because originally they weren't going to permit dried meat products, and that was his product. That was his entire business model, as near as I could tell from his impassioned comment. And he had what he thought were very good reasons why it should be permitted. But I think that the rule sort of was picturing it as a meat product, which wouldn't be food safe for long, and they had originally banned it. So things like that, you can have your more esoteric or unique product if that's what you're planning. You definitely need to pay attention during this process. And then you're going to have questions about things like how do you demarcate each serving? Do you have to stamp something on a product? There can be exceptions for things like liquid. Somebody has commented to us that they have had excellent dried meat products from a medical market. So there you go. They're apparently very popular. But basically, the upshot is you need to make your voice heard during this process because there are going to be questions about, for example, should you allow caffeine in as an additive in a cannabis product? Should you allow naturally occurring caffeine? There's just a lot of moving pieces, and particularly if you are looking to sell something that's more specialized, it's worth paying attention.
Thanks, Michael. And we certainly want people to be involved. And as the person who teaches food safety training to manufacturers across the country, I know that infused pork does have an extra, interesting element that I think most jurisdictions will avoid. All right, everybody, we are going to give you a turbo round of what's next. We're going to go through this in about 2 minutes. So your questions are on deck next. Be typing your questions in, things that you're curious about, and we'll get to as many of them as we can. So, Barton, give us the scoop. I'm just going to reveal bullet point number 1, which is, as you know, if you were on from the beginning, that people that have medical licenses will more easily qualify for adult licenses. And Barton, is there anything you'd add to that? And then tell us what else we need to know here.
That the state has a 2-step process for the application, and step 1 is what we call pre-qualification. It doesn't require the applicant to have a property or even have a city. They can get pre-qualified. They can submit all the information necessary, which is comprehensive, but they can submit that information, get pre-qualified, which makes them more attractive to municipalities that are interested in looking at or selecting licensees. So it is oftentimes a good idea to get pre-qualified. But you do have to get that municipal approval, and so that's what a lot of the work that we're doing, and a lot of the work that needs to be done. That's what's next is work on getting the properties within the cities that would allow them, and getting those licenses from those municipalities, or convincing those municipalities to issue a license or issue the ordinance necessary to obtain a license. And as far as residency, that's no longer a requirement. I saw a question about that. Those that are out of state are able to, out-of-state people are able to get a license here in Michigan.
And we can expect some restrictions for those folks that have opted in. Here are some of the classics. Anything you would alert everybody to as they consider moving their businesses forward?
Every city gets to decide how far away from these particular uses that they would permit their facilities. Generally, we get conservative when looking for properties and say 500 feet, but sometimes they'll make it 1,000. So really every city is different. You know, the makeup of every city is different. Some cities allow them, like in Ann Arbor, they'll allow a facility in a downtown development zone. Many other cities will not. Some cities will allow facilities to be next to churches or houses of worship. Many others, like the city of Detroit, will not. Some cities will permit clustering, which means having facilities close to or very near each other. Many cities will not. Those are special considerations, and it really does require to understand those municipalities a little bit to make a determination as to which one of those things apply.
And I would just add that I have seen the biggest restriction I've seen is 1,500 feet away from schools and churches and things like that. And so I know you mentioned 500, 1,000. It really does vary. So we'll have to see what cities choose.
Correct.
Now, how much is it going to cost people to get involved? Because Michigan is a dual licensing state, and that means we need both state and municipal licensing. Let's see if anyone's got some guesses here. How much is your state license or municipal license going to cost? Thoughts on that? Or maybe you've already applied, or you've got a medical license. All right, our first guess is $50,000. Werner, for the win, the state license is $6,000 and the municipal license is $5,000. So you're looking at $11,000 to get started. And then, of course, the regulatory assessment. Barton, Michael, thank you. Now, the questions have been pouring in, and we welcome you all to head over to your chat feature, and we'd love to answer questions for you. I'm going to cruise through our chat feature and throw a few out there that have been tickling in. So certainly for advertising, there are restrictions. And as Michael mentioned, there will be marketing restrictions on the packaging as well. So TBD on how detailed those will be. All right, keep your questions coming in and we will get to them. Barton, I know you've been at the table for many of these conversations. Is there a specific reason why the secured transporters are distinct and separate from anybody being able to transport to their clients directly, like a cultivator being able to transport to a provisioning center?
Yes, this was one of the reasons why it took a couple years for our Facilities Licensing Act to finally get passed, is because there were significant interests out there that were calling for a distinct license type that individuals, potentially people involved in an alcohol industry, looking at least looking for more of symmetry with respect to that industry, wanted a license type that didn't necessarily mean that they were growing or selling cannabis, potentially because they had other businesses that they didn't want to be associated with that. But that is something that there was just a very strong lobby effort for that license type, and it began with the concept of distributors, and that was done away with, and then it kind of morphed into this mandatory secure transportation license, and that's just what became acceptable to all parties to move this thing forward. It took several years, probably 4 years, to finally pass this this ordinance, or excuse me, that law, and that was one of the sticking points.
So I'm curious, we've got a question about the 109 municipalities that have opted in. Where are they? Is there a website we can look at to see who's in and who's waiting on the sidelines?
Yes, there is a website. The department has a map, the licensing and regulatory affairs that you can Google, Michigan, marijuana, LARA, or licensing and regulatory affairs, and they have a map. I also have a map on my website, which is cannabislegalgroup.com.
Now, this is a great question, and we encourage everybody, certainly as committee members with NCIA's State Regulation Committee, your voice is important. Barton has said that. So people are curious about how to get involved, be at the table, be heard to make the regulations make sense for your business. This is Maureen. I have certainly inserted myself into regulatory groups before, and depending on where you are in the world, it's an application process. I have applied to be part of the work group. For people that aren't accepted on the work group, there's always public comment. Barton, anything else you would say about people getting involved as soon as possible, or best practices to do that?
Yeah, as you said, public comment is generally the easiest way to do it. I am on a number of work groups that had been selected by the department. And that's probably because I'm in the industry. I'm the principal attorney at the top cannabis law firm in the state, or at least one of them, and we're very well known. So, I think that another way is to talk to your legislators. There are some legislators that are very much into these laws, especially late last year. There was multiple bills that were introduced to govern or change or better our existing laws, and by being in communication with them, they're definitely here for the people. That's what they're supposed to be here for. So I think that's another way to be influential with respect to our new industry.
And I would also invite people to start knocking on the doors. If your municipality has not yet said we're in, it doesn't mean they're out, and your voice can influence those decision makers. So being involved with other businesses, chambers of commerce, your mayor, etc., to make sure that they choose in. Great.
Hey, Maureen.
Now, Michael.
Yes, I would just add, as a plug for the State Regulations Committee that we're all members of, if you look at the NCIA's webpage, we put out something earlier this year, the State Regulations Committee, on how to engage with state and local officials. And just as a tease, there is more content like that coming. So that is something that there's existing work product from the committee and more to come to help people answer that question, because it's a great one.
It's true. We're going to have a webinar. We hope you'll join us for that. It will be likely between now and April. Now, people are wondering about how sounds like if you're interested or you are, getting a medical license ASAP is going to be of service to people to be part of the adult use market. So are those medical licenses on a rolling basis? Can people apply for those medical licenses now?
Yes, there are just a rolling basis, and they will not the state will not limit the number of licenses. So if somebody qualifies, then they can get a license.
Okay, great. The NCIA team is not affiliated with any state organizations or regulators. National Cannabis Industry Association is a membership organization designed to promote education, community, and advocacy to move the industry forward. So the members of NCIA are typically all people actively involved either in plant-touching businesses or ancillary businesses. Barton, do you know how many grower licenses were approved at these meetings? Are those numbers going up? What are you predicting?
The last meeting, it went down. I mean, there's only 2 or 3 that were. I think there's only 2 that were approved. So thus far there hasn't been a lot. There's like we previously said, there's been about 50 or 60 licenses in total. We hope to get more. We don't know how many is going to be on each agenda. There certainly could be an explosion of them based upon the number of applications and the timing in which that they apply. But we certainly need more. Supply is definitely going to be an issue throughout 2019.
So there have been some recent recalls for cannabis, and do you anticipate there being more than there's currently 4 safety centers or labs? Do you anticipate that number changing to be able to service the state?
Yes, there definitely will be more. But to talk the issue about the fact that there have been recalls, I think that a lot of people are worried about that as well, affecting the supply, because as we've seen in other states, the allowable pesticides that are allowed to be used is a very small number. And not a lot of suppliers here or cultivators here are used to these testing regulations. And so at the very beginning of the industry, I think it's going to be very common to see more recalls and more failed tests, which is, again, going to negatively affect the supply chain.
We know that every supply chain has a seed to sale or track and trace. Has Michigan chosen their vendor for the track and trace system?
Metric.
Okay, gotcha. All right, folks, we see questions still coming in. We are going to wrap this, but we'll stay on the line to support you with other questions. We are so very grateful for your curiosity, your attention, you joining us today for this webinar. It was produced by the State Regulation Committee with NCIA. And Michael, do you want to give any final thoughts about Michigan and the adult use market and what this means to move us forward?
Sure. Look, this is an exciting time for Michigan. The market is being built in real time, and there's a number of different models of regulation around the country that Michigan can look to, in addition to what it's already doing for its medical market. So if you care about one of these issues that we've talked about, or a number of issues, it's a great time to get engaged at the state level. And hey, look, the NCIA and the State Regulations Committee do important work too. Get involved and make your voice heard.
Thanks, Michael. Barton?
Thank you. We're very grateful and proud to be the first Midwest state to legalize adult use cannabis in this country, and the 10th state to do so in this country. We have a significant market. We have over 9 million people in this state. We have, as I said, the second most number of patients in this country at over 300,000. So we have a very robust market and opportunity here, and these short-term problems that we've been discussing as far as supply, it's gonna work itself out. I can tell you, because I've been very much involved in rolling out this rolling out our medical program, and I will be involved in the adult use program, is that the regulators are reasonable people, and they have been working with the industry, and they've been just, I think, been great so far. The fact that we're not going to have to deal with a licensing board anymore is also a very positive thing as well. So we're going to have a great opportunity here in Michigan, and I'm excited to watch it grow.
It is exciting. This is Maureen McNamara with Cannabis Trainers, and we are excited to help move the industry forward with compliance, integrity, and professionalism. Barton, Michael, thank you so much. It's a joy to be on the State Regulations Committee with you, supporting NCIA members and education. And thank you so much, everybody, for taking your time to learn more about what's happening in Michigan. And here's to you getting involved to change perceptions, create new possibilities for cannabis, and support us moving this industry forward in powerful ways.